right? And I'm not going as per exactly the order. If, based on procedure, if you see subclause 3 of A, then if a party has not been provided notice of appointment of arbitrator or arbitral proceedings, or it is otherwise unable to present its case, right? Now, what we also should remember as a matter of context is that our whole structure for 34 and overall the Arbitration Act comes from the Ancestral Model Law of 1985. I'm not going too much into that because I think you must have already discussed some of these aspects of the influence of the Ancestral Model Law that comes into us. We have not taken everything as it is. We have not taken the New York Convention also as it is, but it is there. Parts of it are there. And we have not taken aspects of the Ancestral Model Law of 2006. These are separate studies that you might want to inform yourself just for contextualization. But many of these grounds are taken from the model law. Mostly it is quite obvious what it means as to when a party is not provided notice of appointment or the arbitral proceedings. What happens is practically how this becomes important is that there are times when proceedings are commenced. They are as per the Arbitration Act. Notice under Section 21 is issued. It is sent by registered post, etc. You might have to go to court under Section 11, get the arbitrator appointed. The arbitration commences. The arbitrator holds a preliminary meeting, issues notice to the other side. Still, if the other side does not come, then it is possible that the tribunal may proceed ex parte, right? One thing that we should know about ex parte is that it doesn't simply mean ex parte doesn't simply mean where the other side doesn't come. Ex parte means that everything under the law required for notifying the other party, all the rights available for notification, they are given already. But the other party, by law, chooses not to come and participate in the proceedings, then it is ex parte. So proceeding can go ex parte, then can be an ex parte arbitral award also. In such a situation, the tribunal will still, a good tribunal will still always assess whatever the claimant is asking for on its own merit. They will examine the evidence, they will check the documents, etc. Only then make a final award. Now, what happens is in such a situation, if the requirements of notice, etc., are not met, if there is some cutting of corners, if uh, any such foul play is involved, or even if it's not foul play, just a matter of oversight, and notice is not provided, then the award can be set aside. But it is the burden on the party who's asking for it to be set aside, and it's a big burden to explain why you did not participate in the proceeding. This is when you don't have notice. But what is important is also the aspect of you not being able to present your case, otherwise unable to present its case. Meaning what? These are situations when you are actually part of the arbitral proceedings. But for various reasons, if you are able to demonstrate that you were prevented from presenting your full case before the tribunal, then also it can be set aside. Basic principle of fairness in procedure. What kind of situations will this come in? It could be if you are able to, and these are very rare things, but if you are able to establish bias on base on of the arbitrator, if you are able to demonstrate misconduct on the basis of the arbitrator or the other side, if the arbitrators don't follow the procedure that is set out under the Arbitration Act or that is set out under their own procedural orders, etc. If there is any fraud perpetrated on the tribunal, or if documents are suppressed, etc., that means you are not able to present your own case. Now, one thing that you should keep in mind is that if you have such an objection, it should be raised before the tribunal at the earliest opportunity first. You may or may not succeed, but courts are getting very strict about these kind of situations where you never raise these things before the tribunal. And then for the very first time, you come in a section 34 or section 48 proceeding and say, I was not, there was bias or there was misconduct or something like that. Courts are much less lenient in such a situations, and they're much less compassionate than when you actually raise this before the tribunal first, and then because you didn't succeed, you made out your case before the court, then they are more likely to consider it. And another practical aspect that you might want to consider is simply saying during the arbitral proceedings that I am participating under protest or I am participating without prejudice to my rights is not enough. Most times it is not enough. If there is an objection, it should be raised properly and before the tribunal. Many strategic considerations are involved. Many rights may get affected. So ultimately, what kind of objection you really want to take is needs a very hard consideration from your end when you're actually participating in the arbitral proceedings. Next bit, similar, not the same, is award can be set aside when the composition of the tribunal or the arbitral procedure is not in accordance with the parties' agreement, unless the agreement itself was contrary to a mandatory provision of the act. I think again it is quite straightforward. If the tribunal is not constituted as per what is said in the agreement, and unless the parties have already agreed, let's say agreement says that there will be a three-member tribunal, but only one arbitrator is appointed, a sole arbitrator. Then the award may be set aside unless it can be demonstrated that you agreed to it. Uh, Similarly, though it is not exactly the same, but if a sole arbitrator is appointed unilaterally, that is contrary to Section 12. Now, there is enough law to say you can't do it. You cannot appoint an arbitrator by yourself. There has to be either court or by agreement. In those kind of situations, the award may be set aside. Uh, but there may be certain situations, say, uh, which the Arbitration Act doesn't allow you to agree to. So those kind of agreements will not be upheld anyway. So it's important for you to understand that, and I think you must have all already gone through this, is that some parts of the Arbitration Act are mandatory. You cannot agree to delete those things in your agreement. Some parts of the Arbitration Act are not like that. Parties can agree which rules they want, which law they want to agree to, so on and so forth. Just to quickly give you an example, if an arbitration is seated in India under Section 28, if it is seated in India, you can't choose law that is not Indian. But if it is for a domestic arbitration, both parties are Indian. But if it's an international commercial arbitration, then you can probably choose. So that is a question of choice. Some places choice is available, some places choice is not available under the Arbitration Act. And if there are choices that are made that are contrary to the mandatory provision, whether it is by the tribunal or by the parties, the award may be set aside. Uh, Now let's come to the jurisdiction bit. Okay, this was a question that was asked. Initially, there were judgments to say that you must raise this objection of jurisdiction at the earliest opportunity. And you cannot raise it then in 34 if you never brought it up in the first place. The only other reason is if to do that, if parties agree to it, or if you, on something similar to that, where you can say that you waived the objection. But in 2018 or so, I think, the Supreme Court in Lion Engineering versus State of Madhya Pradesh had held, Justice Nariman only, I think, had held that there is no bar as such for you to raise a jurisdiction objection for the very first time, even under Section 34 proceedings. Uh, but obviously, you will have to make out a very compelling case as to why you were not able to do this before. Uh, all it says, I think, ultimately is that you can do it, but your threshold to explain a jurisdiction objection, setting aside based on lack of jurisdiction, will be very, very high. There has been a lot of academic criticism, etc., but that I believe this is the latest on the issue. But in any case, to the extent possible, just as a matter of safety, and again, subject to strategy. Jurisdictional objections should be raised at the earliest possible opportunity. Right. Now, let's go to the arbitration agreement aspect. Arbitration agreement based grounds for setting aside. First is if the arbitration agreement itself is invalid under Indian law, sorry, under the law of the arbitration agreement. So this is a factor of arbitrability partly, and otherwise also partly to do with the Contract Act or whichever contract provision is applicable in the country of the arbitration agreement. But other than that, it's quite self-explanatory that you have to demonstrate that the arbitration agreement is not invalid. So it's a very basic requirement. What constitutes arbitrability and what law applies is now has been recently in debates about what applies, which part of the law is arbitrability law, which law of arbitration agreement applies. But I think those are slightly different discussions. But if you do want to look at what would be the law of the arbitration agreement, I think very recently the Supreme Court has discussed this in a judgment called Dis or Tho. So you might want to look that up. But otherwise, if the arbitration agreement is invalid, then the award can be set aside. And again, this is something you should ideally bring up during the proceedings, but it's a ground that is still available at 34. Second and related is that if the award deals with something that is not submitted to the tribunal, number one, either it is not submitted to the tribunal, parties have not even asked the tribunal to decide, or secondly, it is outside the scope of the arbitration agreement itself. And I would add a third one, which is if it's contrary to the Arbitration Act itself, because there are certain powers are not given to the tribunal unless the parties agree specifically. So the first two are, I think, quite clear. The first is where parties never even requested the tribunal to decide, and therefore they have exceeded their power. Second is the arbitration agreement doesn't allow them to do that because only some kind of disputes are submitted to arbitration. Mostly, as a practical matter, parties agree that all disputes in connection with arising out of etc. will be submitted. So this is a rare objection. But third is, and this is from a contextual perspective, see, tribunals are not actually courts. The awards are treated as if they were decree. And I know what I'm saying sounds very obvious, but what the courts do have is the power of doing equity to establish fairness, even in private transactions and private civil suits, commercial suits, etc. The tribunals, arbitral tribunals, do not have the power to do that. So, unless the parties specifically agree. Okay, so if you see 28(2) of the Arbitration Act, what it says is the arbitral tribunal shall decide ex aequo e bono or as amiable compositor only if the parties have expressly authorized it to do so. So these are again, for some reason, very fancy Latin terms, just to which mean that the tribunal can take decisions of equity and fairness, etc., and justice, overall justice, only if the parties say that they can do it. This and as a practice, it's not very common to see parties specifically saying tribunal can give equitable relief. Uh, so if they do that, then the award can also be set aside. Of course, if the reliefs that are granted are otherwise extending to parties who are not part of the arbitration agreement to the world at large, unless you can demonstrate that they're also parties. So those kind of orders, directions, etc., they also may be said to be outside the scope of the arbitration, and therefore they may be challenged or set aside. Important thing here is that in section 34, this provision that I'm talking about, just one second. Yeah, so if you see, I'm talking about section 34, subclause 2, small Roman 4, right? disputes not contemplated. It's a very important proviso here, which says that if the decision, provided that if the decisions on matters submitted to arbitration can be separated from those not submitted, only that part of the arbitral award which contains decisions on matters not submitted may be set aside. In simple terms, what it means is that if there is some part which we are saying were not part of the tribal, the arbitration agreement or reference, you can keep that aside. They will be set aside. But the other things which are part will still remain true. It's not like the entire arbitration award will be thrown out just because some parts were not uh, part of the reference. Uh, Connecting to this is a very important discussion, but it will be a very large discussion, so I will only flag it. Is the power of the courts to modify an arbitral award. Very recently, this year, the Supreme Court has clarified that courts do have the power to modify arbitral awards. Otherwise, you could probably have set aside the entire award, but there are very rare situations, the court has said, Supreme Court has said, that you can modify the award also, not just set it in, throw it out entirely. So this would be the decision in Gayatri Balasamy, and I encourage you all to go through it. It's a long judgment, but it is a worthwhile read. So that's as far as Section 34's main parts are concerned. Now we come to the dark horse, as they call it, the public policy objection. I'm not going to read out the whole thing, but if you see Section 34 2B, 2, small 2, an award which is in conflict with the public policy of India can be set aside. And you should also read with that Section 34 2A, which is that an arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside if the court finds that the award is vitiated by patent illegality. Now, what are these terms? This has been a matter of debate for so many years now, since the time the Arbitration Act has come, and it is still being debated as what is the public policy of India. Now, if you see the Act itself, you will see three different, there is an explanation which makes it more narrow as to what is the meaning of public policy. It doesn't mean just anything under the world. Okay, it doesn't mean if the award simply violates a legal provision that it of Indian legal provision that it is contrary to the public policy of India. It is not. It's a higher threshold. So I think what we can only see in the statute are guideposts. So it would be, say, if there is fraud or corruption that was involved in the making of the award, or contravention with the fundamental policy of Indian law, or if it's in base conflict with the most basic notions of morality or justice. It's again, you see, even within the sub requirements, there are very high thresholds. So it is not just in conflict with morality or justice. It is in conflict with the most basic notions of morality or justice. So it's a very high threshold. And then there is a patent illegality requirement. There is a plethora of judgments dealing with situation basis when public policy is deemed to be violated or when there is patent illegality. I don't propose to discuss that at a lot of length. Sorry, there's a question of sir. Which were the sections about public policy? Is it that you're asking? It is at section 34. I'll just put it 2A 2 and 2. Okay. Yeah. So these are the sections as far as public policy is concerned and patent illegality is concerned. But let me tell you broadly what it means. Okay, this is a question of what is the scope of interference by a court. I think the guidepost is an award can be set aside when the view taken by a tribunal is not only not plausible, but also that it is completely impossible for a rational person to come to that conclusion. And that is probably the guidepost that you can look at. Yeah. From here, there are a lot of streams that will flow. Okay, one of the things will be that some element of evidence was misinterpreted, or there is no correct appreciation of, there is no correct approach towards the evidence, etc. But also in the guidepost is that you cannot, even in 34 under public policy, patent illegality, all of this together, the principle is number one is that the arbitrator is has the final word on the facts. There are exceptions, which I'll tell you. But the arbitrator has the final word on the facts. The arbitrator's views and application of the law, it may be wrong. Sometimes it is wrong, and sometimes it's not wrong, but the another person or another court might have come to a different conclusion. That also is not open to challenge. It is the arbitrator's power to deal with the evidence and appreciate the evidence. In a 34 proceeding, evidence is not supposed to be appreciated, reappreciated. But if you are able to demonstrate that based on whatever is already available, there is simply no way that any rational person could have come to a conclusion based on what the arbitral tribunal has come to a conclusion. Only those situations you will find that there is a patent illegality, and in which case the award will be set aside. As far as public policy itself is concerned, fraud is a very high threshold. Corruption also, you will have to make out a very beat a very high threshold to demonstrate that there has been corruption. And corruption on whose part? On your part or the other side's part, or how is it? So that will be one. Especially because something like corruption is involved with authorities. So most likely the authority will have to demonstrate that there is a corruption, but it's a double-edged sword. So it is something that has to be dealt with sensitively, but it has to be dealt with. The fundamental policy of Indian law. Now, see, there are judgments which say that certain provisions under, say, FEMA, the Foreign Exchange Management Act, it's just because the award directs, and especially in cases of foreign awards, where if a party is getting assured returns in a cross-border transactions, generally assured returns are not allowed in specific situations under the FEMA. But that by itself, the courts have said, that by itself is not grounds to say that it is against public policy, because there are provisions in the FEMA which say that you can ask FEMA for that approval. So it has to be a very high threshold. If it's something completely to the Indian export policy or completely contrary to the fiscal policy, but that is a very high threshold again. So that is as far as patent illegality is concerned. As far as public policy is concerned, patent illegality also we discussed. The most important judgments dealing with that is, I would say, Associate Builders of 2015, which had explained what the grounds for setting aside should be. But one of the grounds which subsequently, for patent illegality, was subsequently removed is what we call the Wednesbury Principles of Reasonableness. There's old English law on what they call the Wednesbury Principles. I'm not going to go too deep into that, but it's basically certain actions that administrative or cautionary principles that administrative authorities have to abide by, meaning they cannot be arbitrary, it cannot be completely irrational, etc. But importing that principle into setting aside an award as a patent illegality ground was criticized, and rightly so, and it was ultimately recommended by the Law Commission in the 246th Law Commission report that this Wednesbury principle should not be applied, because you're broadening the scope of challenging an award. So back to what it still is, it's simple. If something that shocks the conscience of the court, something that is completely impossible, and no reasonable person would have come to such a conclusion, only then patent illegality ground is met. Uh, One of the things that, as just as a principle, you might want to consider is that this ground of patent illegality is available only in case of arbitrations that are not international commercial arbitrations. Now, which means that at the very same time, there could be a domestic arbitration going on in Mumbai, which has two Indian parties. There could be an international commercial arbitration in Mumbai, which has one Indian and one foreign party. But the domestic arbitration award is subject to patent illegality. Foreign arbitration, the ICA, seated in Mumbai itself, and it's governed by Arbitration Act, Part 134, everything. But it does not have a patent illegality cap or requirement not to have patent illegality. Is this valid? Is this a constitutional provision? Is this an intelligible differentia? Is there reason to treat these two differently, domestic and ICA? Why there should be a higher threshold for domestic arbitrations is something that you might want to explore. I don't have an answer, but as of now, that provision is as it is. That in domestic cases, there will be patent illegality requirement, or that it should not have patent illegality, but that bar is not there for international commercial arbitration seated in India. So, okay, I understand that we are drawing very close to the end, and I have covered most of the points that I wanted to discuss. I think for as far as foreign awards are concerned, the grounds are mostly the same. What they don't have is patent illegality. Okay. Foreign awards cannot be refused enforcement on grounds of what we call patent illegality. Some formal requirements that are important is that under Part 2, you have to, before you seek an enforcement of the award, uh, it's not that you have to file a separate proceeding for recognition and then another proceeding for execution, but the award has to have some basic requirements. First is under Section 44 of the Arbitration Act, which set out what constitutes an award as per the New York Convention, and only those foreign awards are enforceable in India as far as the New York Convention chapter is concerned. One of the important things over there is that uh, the country where this award is passed has to be notified as a reciprocating territory by India. So it's not enough that the other country where the award is passed is a party to the New York Convention. India is also party. There are many parties to the New York Convention. But the country has to be notified specifically by the Indian government in a gazetted notification. Only then that award will be enforceable in India. Which countries are designated is something you can find out. There is a gazette notification for that. That is number one. The other is under Section 46, the award should be final and binding. It's 46 and 46. It should be final and binding, meaning what? It's simple. In India, an award is passed, it is subject to 34. So until the time of our challenge ends, you cannot enforce it. So there may be similar requirements in, say, Singapore or UK, or wherever else. Until the award becomes finally executable, you cannot ask for enforcement in India. And lastly, under 47, you have certain formal requirements that you have to produce a copy or at least a certified copy of the award and the arbitration agreement. Other than that, under 48, the grounds are very much similar. Uh, Refusals for enforcement of foreign awards is very rare. We have been consistently, India has been upholding foreign awards. Right from, say, if you check the Supreme Court's decision in Renu Sagar, which was, I think, in the 60s or so, where they developed this principle of public policy. What is public policy and why it is limited? That it only applies to fundamental policy of Indian law, etc. So it is important that you take a look at that decision. All the way up to very recently, say decisions like Vijay Karya, of the Supreme Court in 2021, where they refused to interfere or refused to uh, take on, or rather allowed enforcement of a foreign award, even though there were objections in terms of FEMA and some requirements not being met, etc. But one of the rare refusals recently, if you ask me, was this decision called NAFED versus Alimenta, National Agricultural Cooperative Marketing Federation of India versus Alimenta SA. This was actually a 31-year-old award, but it was being dealt with in 2020. So the Supreme Court found ultimately that the contract that the parties were involved with, one of the aspects was for NAFED to deliver, supply some goods to Alimenta. For that, this company NAFED, they had to secure an approval or license from the government of India. That license was refused by the government for whatever reason as a policy measure. And then NAFED could not comply with its obligations. And therefore, the other side, Alimenta, said this is a breach, etc. And the tribunal upheld that breach. Ultimately, in the Supreme Court, and this, remember, this was being assessed not under the current Arbitration Act, it was being assessed under the 1961 Foreign Awards Act because it's an old award. But the principles of Renu Sagar are still alive even that time. They were available. But the Supreme Court said they went into the contract itself and they found that the contract was actually a contingent contract, that the contingency was the government of India could or could not have given their approval. So the tribunal's decision is contrary to public policy and therefore it should not be enforced. So it is a rare decision. I think it does not discuss Vijay Karya or the decisions that came before it, but it's an important decision where enforcement was refused. I think the last part that I had to say a few words on, and there's not a lot, but that is in terms of the execution of an award, the actual execution of an award. So, how it works generally is that when you have an Indian award or you have a foreign award, actually, there is no real bar as to which court you go to, but it is guided by a certain few practical things as well. One is where are the assets of the award debtor? Because see, if you have a money award and the other side is not complying with it, you might first thing you might want to do is to attach properties of the other side and then have those properties sold and get monies towards your award, your compensation. So now there's some element of strategy also involved here. So if you know that the other side is going to dispose of properties, is going to put it in somebody else's name so that they don't have to pay for it, etc., then you might have to also file post award section 9 applications to get interim relief immediately to say that none of the properties should be dealt with. As an award debtor, if you really do have grounds for the award to be set aside and you believe that there has been fraud or corruption or something, or some whatever reason that you think the award is not right, then you may go under section 9 and request that these properties should not be attached and should not be affected, so on and so forth. So I'm just giving you examples of what preservatory steps can be taken or prior steps can be taken. Apart from that, I think the execution requires that you sometimes, as a practical matter, even when you're commencing the arbitration, right at the time of commencing the arbitration, parties sometimes engage asset tracing agencies, etc., so that they already have a profile for what properties are owned, where are those properties, etc. It's practically also what happens is you file the execution application, and even though you may know that a particular property belongs to somebody, that other side, award debtor, it has to be proven in court. It can become a question in court. So, a lot of times, one of the requests that you have from an executing court is that please direct the award debtor to file a disclosure affidavit. Disclose on an affidavit what are my properties, what is the valuation of those properties, and then you seek relief in terms of those properties. Uh, asset tracing. You trace the assets. There's a question of, yeah. I think there's a question: how does an arbitrator draft an award to minimize the risk of non-enforcement, conflict with public policy, etc.? See, there's no straight answer to this, but one thing I can tell you is that when you're drafting an award, you should draft, or when meaning the tribunal is drafting an award, generally what happens is that they are not going to draft only from the fear of it being set aside in some other country's public policy. But that being said, as a lawyer and as while making submissions, etc., you will also, of course, make submissions in a manner to ensure that the award, the final relief that is being asked for, is either it's not in contravention with Indian public policy, or if you're the opposite side, you will point out that if you pass this award, this will be contrary to public policy. One decision that you might want to discuss or take a look at is the Anupam Mittal dispute that took place in Singapore, where the Singapore courts held that a dispute that actually does involve some elements of or possible elements of operation mismanagement, they can be dealt with in Singapore, but and Indian law didn't apply, even though under Indian law O&M disputes cannot be arbitrated. So they went ahead in Singapore, but in India, our court, Bombay High Court and NCLT said you cannot do this. So there was a conflict. These questions are not very straightforward, but yes, ideally a tribunal should consider if something is going to be completely contrary to India's public policy, and it should be avoided. I think that's pretty much about it. And I think, sorry, I've also crossed the time. But if there are any quick questions, I'm happy to address them.
Yes, students, if you have any questions, you can just unmute yourself and ask the questions, or you can drop it in the chat box. I think so. No questions. It was self-explanatory. The session was quite self-explanatory. So elaborative one.
I hope there was not too much of an information overload, but if there's, I hope it was helpful. I think there is one question after attaching the properties, what will happen? See, what happens is after, number one, you get the properties attached, then you sell the properties. So you get a court order to sell the properties. Yes, will they sell it and off and pay the party? Yes, you will have to get a court order to have the properties sold, and then those amounts will be adjusted against your claim. So all this is governed by the CPC. Then you go into the stage of this. It's the same for civil suits. So yeah.
So I think so. We can move to the valedictory session, sir. Shubham, sir.
Okay. Thank you, Ritvik, sir. It was a wonderful session. Thank you so much. So, I'll start with a slok. Anudvekaram vakyam satyam prihitam chayat swadhyay bhyasanam chaiva vangamayam tap uchyate. Words that do not cause hesitation, that are truthful, pleasing, and beneficial, and the practice of self study. These are said to be austerity of speech. Today's theme of Falasiddhi has been a profound reminder that justice is hollow if unenforced. Much like Lord Krishna's wisdom, that speech must be truthful, pleasing, and beneficial. We are reminded that enforcement too is the voice of justice, ensuring that what has been decided does not remain mere words but becomes living reality for those it impacts. We have learned that arbitral awards, when enforced effectively, do not just resolve disputes, they build trust in the system, they save society, and they uphold the dignity of law. Over to you, sir.
At this juncture, it's my privilege to extend heartfelt gratitude. We are deeply thankful to our Dean and Principal, Dr. Ujwala Bendale ma'am, Vice Principal, Dr. Jyoti Dharam ma'am, IQAC Coordinator, Vidya Dhere ma'am, whose unwavering encouragement and constant guidance has helped us. A special thanks to my colleague, Mr. Shubham Tripathi sir, without whose vision this course could not have been crafted. A very special Thanks of note to today's resource person, Advocate Ritvik Kulkarni sir, whose professional expertise has enlightened us and inspired us to embrace arbitration as a living, evolving practice of law which upholds justice and dignity. On behalf of the organizing team, I sincerely appreciate the presence of all the dear participants for the active engagement. With these words, we formally conclude today's session of On Falasiddhi because winning is not just enough, justice may be lived. Thank you, everyone. Thank you, Ritvik sir, once again.
Thank
Thank
you.
you, sir.
Sir, one for snap is required, sir. Rohit, sir,
Yes,
please.
all the participants are required just to on your cameras. We'll have a group photo. Ansh, you can help us with the snap. Thank you, everyone. Uh,
Thank you. Thank you so much.
thank you,
Thank
Thank
you,
you,
Ritvik.
sir.
Ritvik, sir. Thank you
All
so
the
much.
best to everyone. Thank you so much.
Thank you so much.
Thank you, sir.
Bye.
One
Bye.
announcement for all the participants that we have shared the problem on the group and we have also made the groups. So whoever are there in the groups, you just prepare yourself for tomorrow's mock arbitration. Tomorrow's mock arbitration will start at 5 o'clock. So you'll get the links by morning. So tomorrow's arbitration is at 5. And if anybody has any query regarding how the mock arbitration should go, you can coordinate with Ansh Verma, student coordinator, or you can call us also. Basically, we have made teams of three. So two participants will be the they will be doing the arguments, and third will be the arbitrator who is going to write the arbitration award. You have to be prepared with your arbitration award. Tomorrow you'll have to present your arbitration award. So this will be the scheme which has been already published on the groups, and it has been told time and again. So please be ready with tomorrow. And if anybody has any doubts, you can just ask across. And just on the group, confirm when you are ready with your team so that tomorrow we'll line accordingly. Is that okay, sir? Shall we end?
Yes, sir. Yes, sir.
Okay. Thank you, everyone. Thank you. Thank you, sir. Thank you.